Yeah, and this was the result of the argument at the district court level in Washington, D.C. The case got transferred from Seattle, where it was initially filed, out to D.C. in the summer of 2004, following the Supreme Court's ruling in the Padilla case, which gave guidance on proper venue for habeas filings. And we were in front of Judge James Robertson, who himself, I believe, was a former, naval officer, and he halted the commission process in a fairly dramatic fashion. The commission process was engaged in pre-trial hearings. Lieutenant Commander Swift, Neil Catmull were down there at Guantanamo, and an officer walks in and hands, a note to the presiding officer of the commission. He reads it. He stands up and says, okay, we're in recess. He comes back 5 minutes later and says a federal district court judge has issued an injunction halting this process. This decision, of course, was immediately appealed, and the government asked for expedited treatment by the D.C. Circuit Court, which it received.
Yeah, and we drew an unfortunate panel and got an unfortunate result in the D.C. Circuit. It was heard before a 3-judge panel. Well, let me first say we actually sought, while the government was seeking appeal to the D.C. Circuit, we actually sought cert before judgment in the Supreme Court, which is something that the court does extremely infrequently, but it actually done in one commission case before. The Supreme Court said no, so we go before the D.C. Circuit and lose pretty resoundingly there. I mean, the government, the only thing that the D.C. Circuit agreed with us on was that they did not need to abstain from ruling on the merits of the case. They said, well, we can go forward and hear your merits arguments. Nonetheless, they're all bad arguments, and we find none of them to be persuasive. And this, I don't know if any of you have had an opportunity to look at the Supreme Court's final opinion. It's 185 pages. I mean, that includes all of the dissents and concurrences, of course. The D.C. Circuit's opinion is 15 sort of West Reporter pages. I mean, no matter where you come down on Hamdan, this is really a big case. And the idea that it could be sort of raised and dismissed in 15 pages, we found to be pretty extraordinary. But nonetheless, we got this bad ruling, and so we immediately, in fact, it came down in July 15th of 2005, as the slide indicates, and we had our cert petition on file by August 7th, actually, of 2005. I think we had been aware for a while that this was where it was headed. And if July 15th wasn't a bad enough day, then we had July 19th. And I had a special effect all geared up, and it didn't work. I had this comical sound that was supposed to play. So one of the judges on our panel in the D.C. Circuit was then Judge John Roberts. And 3 days after the opinion comes out of the D.C. Circuit, he is nominated to be Chief Justice of the U.S. Supreme Court. So July 19th was a bad day. The court's composition hadn't changed in 12 years. And basically in the summer of 2005, it changed in substantial ways, in ways that were not good for us. Of course, Justice O'Connor retired and was replaced by Alito, and he voted the way we expected he would vote. Judge Roberts replaced Justice Rehnquist, of course. Now, Roberts ultimately abstained from hearing the Hamdan case. He did not sit on oral argument. He participated in no way in the conference to decide whether to grant cert, none of that. But that wasn't necessarily a positive thing for us, because what it meant was that it raised the prospect of a 4-4 tie, and under court rules, a 4-4 tie means that whatever the lower court did is affirmed. So a tie was a loss for us. And this is kind of an aside, but Justice Rehnquist, each justice has kind of their little pet issue, and I think Scalia likes paper mache or something. That's what he does in his free time. But Rehnquist had written pretty extensively about the effect of the Constitution in wartime. Had written a lengthy book, All the Laws But One, and so he was a question mark, we always felt, because he he was very well versed in these issues, and we thought anyone well versed in these issues would come out our way. But nonetheless, this is the court that we went up there with, and